Am I covered if my on-the-job injury is caused by my own negligence? Morning, everybody. My name is Jim Aspel. I'm a board-certified workers' compensation attorney in Farmington, Connecticut. Now, we all know that unfortunately, on-the-job injuries are all too common. Sometimes, however, our on-the-job injury is attributable to something that we do. Common example would be if you're a contractor and you inadvertently aren't paying attention and you cut off your finger while using a table saw. You're a visiting nurse or you're some other on-the-road worker and you sustain injuries in a car accident when you rear-end somebody else. In that instance, the accident would be your fault. These things happen. Occasionally we're humans, we make mistakes, and occasionally we get hurt as a result of something we do. In Connecticut, if your on-the-job injury is caused as a result of your negligence, by and large, you are going to be covered for workers' compensation benefits. Workers' comp, unlike a typical tort case, is a no-fault system. So in other words, you're entitled to coverage for workers' compensation. You're going to get your medical expenses paid. You're going to get your cash replacement payments made. And you're going to be eligible for a permanent partial disability award, regardless of whether or not your injury was caused as a result of your own negligence. There's no comparative negligence. There's nothing of that nature. Typically, if you get hurt on the job, regardless of how that occurs, you are going to be covered for workers' compensation. There are two primary exceptions to that. First and foremost, if your injury is caused as a result of your intoxication, either by alcohol or illicit drugs, then that's going to be an absolute defense to the workers' compensation case. If you're intoxicated and you're out there and you fall off a beam and you hurt yourself, unfortunately, in all likelihood, you are not going to be covered for workers' compensation benefits. The other really common exception that we see is horseplay. So in other words, you get into some sort of disagreement or an altercation with a coworker, you're fighting, as a result of the tussle, you sustain injuries, you dislocate a shoulder, you break an arm, whatever it happens to be. If the injury is caused as a result of the horseplay, then by and large, that's not going to be covered under the Workers' Compensation Act either. Now, obviously, every case is different and requires an investigation into the particular facts of the situation. That's where a workers' compensation attorney comes in. But by and large, unless the accident was caused by your intoxication or some sort of willful misconduct on your part, you are going to be covered. I'd be happy to answer any questions you have with regard to this particular topic. You can call me. We're in Farmington, 860-523-8783. You can message us on Facebook. I invite you to join my Facebook group, Ask a Connecticut Workers' Compensation Attorney, or you can visit our website at www.aspbellaw.com. We have plenty of information there on this topic and a bunch of other stuff as well. I hope you've enjoyed this video and found it helpful. Talk to you next time. Thank you.